This court refused to consider that affidavit as its submission in reply papers deprived defendants of the opportunity to challenge its sufficiency. Consequently, the court denied the motion in all respects in a decision and order entered November 27, 2001. In a third effort to give continued viability to their claims, plaintiffs again move for leave to amend their complaints to set forth factual allegations that will permit them to rely upon the extended accrual date established by CERCLA. In support of this motion, plaintiffs have offered their own affidavits, together with those of certain former IBM employees, a transcript of a deposition of another IBM employee, and an affidavit previously submitted by an expert witness in the Ruffing case. Those affidavits and the transcript present evidence that while Mr. Fledging was employed at the New York plant, he was exposed to hazardous chemicals not just in the course of his work, but as a result of accidental spills and leaks inside and outside the plant, and intentional discharges of chemicals into the grounds surrounding the plant, the latter of which allegedly resulted in the contamination of the water used for drinking and washing by IBM employees. In sum, plaintiffs' submissions are intended to demonstrate that there is merit to their claim that Ms. Fledging was injured as a result of her exposures to chemicals brought into the Fledging's home on Mr. Fledging's clothing and on and inside his body and passed to Ms. Fledging in utero. As plaintiffs correctly assert, absent a showing of prejudice, leave to amend a pleading should be freely given. CPLR 3025B. C. Edenwald Constructing Company, Incorporated versus City of New York. 60, New York 2nd, 957. Certainly, while defendants are correct in their assertion that the dismissal of the complaints granted in the June 2001 decision bars plaintiffs from seeking leave to amend on a new motion with respect to the dismissed actions, nevertheless, we will consider them currently. That general rule notwithstanding, leave to amend is not to be granted upon the mere request of a party without a proper basis. Consequently, it is incumbent upon the movant to make some evidentiary showing that the claim can be supported. Ibid, citation omitted. It is then the motion court's obligation to examine the underlying merit of the proposed claims, since to do otherwise would be wasteful of judicial resources. Ibid. In opposing this motion, defendants do not argue that the granting of leave to amend will prejudice them in any manner. Rather, their central argument is that plaintiffs have failed to establish that their proposed amendment has merit, because the determination of whether plaintiffs have made the requisite showing of merit turns upon the application of the controlling CPLR and CERCLA provisions. The starting point for the court's decision is the relevant statutory language. In New York, a cause of action for personal injury must be commenced within 3 years of the tortious conduct. CPLR section 214 brackets 5. Previously, claims for personal injuries resulting from exposure to harmful substances were subject to the same 3-year statute of limitations and accrued as of the date of the inquiry. See Steinhardt versus Johns Manville Corporation, 54, New York 2nd, 1008, 1010, 446, New York Supplement 2nd, 244. In this case, since the enactment of CPLR Section 214C, hereinafter Section 224C, in 1986, where it is claimed that an injury has been caused by the latent effects of exposure to any substance or combination of substances in any form upon or within the body, That 3-year period shall be computed from the date of discovery of the injury by the plaintiff or the date when, through the exercise of reasonable diligence, such injury should have been discovered by the plaintiff, whichever is earlier.
Okay.
You got in utero in your dictionary?
I don't know.